A federal judge in Washington ruled today that the government's collection of phone records of millions of Americans is likely unconstitutional. It is the first time that a federal court has ruled against the once secret surveillance program, which was exposed by National Security Agency leaker Edward Snowden. In a blistering attack, Judge Richard Leon said he has little doubt that the author of our Constitution, James Madison, would be aghast at what Judge Leon said amounts to an unreasonable search. The judge granted a preliminary injunction to stop the government from collecting the records of the two men who brought the challenge, but then he put that order on hold in the face of a likely appeal. Senior correspondent John Miller is former deputy director of national intelligence. And John, what is the NSA's argument for collecting this information?
Well, Scott, this is all about collecting the massive database of phone numbers dialed by Americans. Now, the NSA is legally barred from spying on Americans, but the agency is supposed to gather foreign intelligence that will help prevent another terrorist attack on U.S. soil. Now, since 2006, whenever the NSA has learned of a phone number being used by a terrorist group overseas, one of the first things they want to know is that suspect talking to anyone in the United States? To answer that question, the NSA obtained a blanket order from the Foreign Intelligence Surveillance Court. It allows the agency to collect the records of what numbers were called by what other numbers and when. The database contains no names, just the numbers, times, and dates. The lawsuit, brought by privacy advocates, claims that the massive data collection by the NSA violates privacy. The court ruled that the NSA should get an individual court order to obtain the records in each case, rather than relying on a massive database. The NSA's director told me in an interview for 60 Minutes that would present problems for his agency in tracking terrorism suspects on U.S. soil.
Well, the reality is, if you go and do a specific one for each, you have to tell the phone companies to keep those call detail records for a certain period of time. So if you don't have the data someplace, you can't search it. The other part that's important, different phone companies have different sets of records, and these phone calls may go between different phone companies. If you only go to one company, you'll see what that phone company has, but you may not see what the other phone company has or the other. So by putting those together, we can see all of that essentially at one time.
In a written opinion, the court called the program almost Orwellian and said, "It's one thing to say that the people expect phone companies to occasionally provide information to law enforcement. It is quite another to suggest our citizens expect all phone companies to operate what is effectively a joint intelligence gathering operation with the government."
Now, John, when the Snowden revelations came out, the president put a commission together to look at whether the NSA's practices should be changed. That commission has written a report. It's not public yet, but you have some information about what they've come up with.
So interestingly, apropos to today, our sources say that that commission is going to recommend largely the same thing, which is that the NSA stop keeping that massive database, that it either lives somewhere else, maybe at the phone companies, and that they get an individual court order for each case. Now, just important to note, the database is just the telephone numbers. There's no names in it. To do that, they'd have to give that to the FBI, and they'd have to track down who that number belongs to using warrants and things like that.
John, thanks very much.